Hi, Satang. Thank you for honoring my invitation to join the podcast. Celebrate your work, your achievements, and it's really an honor to have you on the podcast. Good evening.
Good evening. Yeah, thank you for having me. I'm very excited to be on the podcast.
We're here in honor of your book launch, and I would like you to introduce yourself to the audience and what is it that you do, and your relationship with the center.
I do a lot, but sure. Yeah. So I'm Satang Nabaneh. I'm from the Gambia. Okay. My relationship with the center started back in 2011, I think, when I came for the mood court competition in South Africa, which was my first time, and I was doing my undergrad. I participated in the mood court competition, and then in 2012, I actually got into their HRDA program as the youngest in the class, which was very exciting. So I spent the year here, part of the year with an incredible group of colleagues and friends who are lifetime friends all over the continent, and spent the second semester in Mozambique. I went back to the Gambia, lectured at the University of the Gambia, as well as coordinate the Female Lawyers Association. But yeah, since then, I have been a part and parcel of the center. There is something with the center that, when you come in, it's for life. Not to mention with the Pretoria Mafia as well. And then I also did my LLD here at the university with Professor Charles Ngwena as my supervisor, as well as Professor C. Glopin at the University of Bergen as my co-supervisor. And I have been an integral part of the Sexual and Reproductive Rights program as well. And so teach, supervise students. And during the doctoral period, I was also part of the Women Rights Unit, supporting the Special Rapporteur on the Rights of Women in Africa. So the center, I am...
That's a lot.
I am at the center. Yes.
Yeah.
And just coming back to the question around what I do, on the side, apart from that. So I do consider myself an African feminist researcher, scholar, and activist. Okay. I started as a child right activist when I was 8 years old in the Gambia, and so activism has always been an integral part and led me into academia. And so, and that also speaks to the book as well. I'm very much interested in how we, bridge the divide between theory and practice. Research, academia is as vital as how we ensure that the research that we do is useful for grassroots organizations as well as other stakeholders, especially in changing the lives of people. So yeah, I am.
Perfect. That's very nice and not humble introduction. But thank you for giving us that.
Sure.
And I'll also show the audience the word that,
Yeah, sure. Yeah. The title of the book is Choice and Conscience, Lessons from South Africa for a Global Debate.
Okay. I want to ask, very importantly, what inspired you to write this book?
Yeah, so I think this book is a sort of a culmination of the journey that started, I think, back when I started the HRDA, because my mini dissertation, for example, was on Article 14 of the Maputo Protocol and access to safe abortion. And then my doctoral research was also very much focused on access to safe abortion, but most especially looking at the issue of conscientious objection. So when we talk about conscientious objection, we're talking about the implied right of people to refuse to do something based on their personal religious and moral beliefs. And this is an implied right that's provided. For example, it is grounded, the argument is that it's grounded in the right to freedom of conscience, which, as we know, is provided for in international regional human rights instruments as well. But I think particularly for me, as I said, I was very much interested in how my research is not just legal research. So this research is a social legal research that informed the book itself, that really brings together both in relation to applying, obviously, looking at laws, judgments, and doing doctrinal analysis, but most especially applying an intersectional and African feminist perspective on the provision of abortion services, especially within the South African context. And so looking at the role of mid-level providers, and when I talk about mid-level providers here, I talk about nurses and midwives, especially within the South African context, where, as well as similar to what we've seen in other African countries as well, now mid-level providers are actually being given the mandate to provide abortion services, especially especially in the first trimester. So that means that they play a critical role in terms of access, and that's really where it is really from. So yeah.
The title of the book is very, very intriguing.
Yeah.
What is the significance of that particular title?
Right. Yeah. So the title is sort of like a wordplay on the issue of the conscientious objection, as I said, and other people will say obstruction to access or refusal to care. And so the idea is choice and conscience speaks to the way that the book actually covers the issue, right? So it just doesn't cover, for example, the issue of nurses and midwives who refuse to provide abortion services, right? But it also uniquely covers the lived experiences of nurses who, due to their own religious, moral, or whatever other reason, are willing to go out and actually provide abortion services. So it is like a play in relation to juxtaposing both those that provide and those that do not provide. And then in more technical terms, we have the term of conscientious objection as well as the term of conscientious commitment as well. And so so the play of words is really that this book really looks at the reasons and try to as it relates to legal, political as well as social-cultural factors that influences why nurses provide or do not provide abortion services, especially within a legal context, within the context of South Africa, which for the past 23 years or more really has had a very robust as well as a liberal legal framework, both in terms of the Constitution, but also in terms of the Choice on Termination of Pregnancy Act as well.
Okay,
yeah,
perfect. That's a very good and interesting take. What are the main arguments that are in that book? Like, what is it that you are fighting for?
So a couple of things. I think before going to the main arguments, I think is starting from the point of what is the story of the book, right?
Yeah.
So the story of the book is one, it is African relevant in a sense that due to the differential legal regimes that we have in the continent, we have had limited contribution and scholarship, especially as it relates to the topic, but also from an African feminist perspective has been very limited in terms of the existence scholarship. And then South Africa is taken as a case study of what a liberal abortion law looks like in action, right? And specifically about that. And then, as I mentioned, the second part of the story, which I'm very excited about, is really about nurses and midwives and their lived experiences. And so part of what that does then is to say, especially with regard to some of the main arguments, one in relation to the legal argument, is that due to the fact that South Africa has a liberal abortion law, as I mentioned, the Choice on Termination of Pregnancy Act, which did not necessarily provide or regulate the practice of conscientious objection. And so what this meant is that it creates more of a discretionary space where healthcare providers, including nurses and midwives, can provide or not provide, regardless of the fact that there is ambiguity in relation to the law. And so the argument then becomes that due to the discretionary space, access to abortion services for women and girls is impacted. And then really then grounded it on and in international human rights norms and standards to say there are standards that can be useful as we regulate the practice of conscientious objection and what that looks like for the South African context. And so what I then did was, especially on the legal side, was not just to look at the normative framework within the South African context, but also doing a comparative analysis. And so part of the book, especially I think chapter 6, if I'm not mistaken, really focuses on what does the regulation of conscientious objection looks like within the South African context, both in relation to utilizing the South African Constitution as well as international regional human rights norms and standards, but also drawing lessons from other jurisprudence. And so, for example, Latin America has very progressive jurisprudence, especially in relation to the regulation of abortion, especially conscientious objection. And so I drew quite a lot, especially from the Colombian court as well as from the other Latin American context to say, if South Africa is thinking about regulation, this is what it might look like, right? These are the minimum bench standards in relation. If a healthcare provider says, I will not provide abortion services, they have a duty to refer to another healthcare provider. They do or cannot refuse to provide in an emergency, and so those standards, but also in relation to what the standards should be, especially if, as I know, and I'm part of several sexual and reproductive rights organizations within the South African context and beyond, where there is now a thinking about what does it mean, for example, to take a case on conscientious objection to the court. So we have jurisprudence from that. And so part of what I did with the book is really saying, based on what is currently happening, this is the strategy or the legal strategies and the approaches even for the court to think of as they regulate that. So that's more of the legal part. I know that might be boring for for some people. But yeah, but the other exciting, I think for me, the other exciting part, as I said, was really in terms of looking at the lived experiences of nurses and midwives. And so the argument there is really that it is not a one size fits all, especially when you look at the process of decision making by nurses as it relates to whether they will provide or not provide, whether they will assist or not assist in relation to providing legal abortion in that sense. And so what the argument for that really is, especially with regard to the book, is that it needs to be locally contextualized, right? And also looking at an intersectional analysis where we see, especially from, and you can read later, I mean, there are extracts, especially in the tone and the voice of nurses and midwives, in relation to that, what we think are the reasons for why nurses and midwives will say, no, I will not provide abortion services differs, right? So in most cases, especially from, even though it is a small sample, right, but it can also speak to what is currently happening, is that quite a number of nurses are not necessarily, saying no to everything, especially when it comes to providing abortion services, but they will be considered, situational objectors in a sense, right? Situational objectors in a sense that they are willing to provide abortion services, for example, in cases of rape, as well as other such situations that entails violence, for example. But in other cases, they are like, no, I wouldn't provide abortion services because this is repeat abortion or due to failed contraception, as well as others. So I think part of what this book offers really is, an insightful and I hope new perspective that bridges just, the scholarship that is really siloed, right? Scholarship that is really looks at the legal element, and scholarship that really looks at healthcare providers' attitudes, but also beliefs as well, and really tries to bring these two very different worlds together, because the reality is that as we talk about the provision of abortion services, the law intersects obviously with public health, but also with politics as well.
I'm pretty sure most of the findings in this book have been through excessive and intensive research. And I want to know personally, what are your takeaways from the whole total experience of the research?
Yeah, so I mean, a couple of things. I think one is, as I mentioned during the book launch, was really that I was struck by the bravery, the commitment, and the resilience of nurses and midwives who provide abortion. Because in one of the chapters, I sort of analyzed the data, especially as it relates to the challenges that they face, right? And one of the key challenges that they face obviously has to do with stigma, being called baby killers, being called other names, but also the work environment not being supportive, as well as the hospital or the clinics not being very supportive in that sense, and so making their jobs difficult. So I think one thing I really take away is that despite all of that, they come in day out, because they know that, for example, and which is unfair, right? That if, for example, they do not, or they're out for the whole week, that means that, abortion services in a particular clinic is at a standstill, right? What does this look like, and what does it take for someone to wake up despite all these challenges every single day to go out there and do this as well? And I think for me, I think that, just the other bit in terms of just doing the process, I think apart from the recognition of the engagement of these nurses and midwives, it's also just in relation to other people that are doing the work as well. But also I think part of it is also coming from a position where as lawyers, we like the law, which is great. And I think it is important, and that's part of the argument of the book, right? That we do need regulations in relation to conscientious objection. But I think what I try to do with the book as well is really also saying, let's look at the law in action, right? That laws do not exist in a vacuum. And as we think of, coming up, whether it's liberal abortion law or it's coming up with other laws that advances the rights of women and girls as well as other more marginalized groups, it is important to also acknowledge the circumstances that the laws exist and how to really address those as well. And for me, as I said, as an African feminist scholar and researcher, I was very much cognizant of my positionality coming in both as one that is a human rights lawyer, a human rights activist, and obviously pro-sexual and reproductive rights. So I was very aware that I had biases as well, but also making sure that, especially in the research process, that I do not invariably, especially when talking to other categories of people that did not necessarily support abortion rights, not to articulate my own personality and my own perspective, right? It was hard, obviously, in relation to that. But I think for me, what I also reflected in the process as well was that I am doing research in South Africa, on South Africa. I am not South African, right? And so acknowledging that and making sure that that was really at the back of my mind as I did the research was also knowing that I was not in a position, and I don't think anybody is, to say this is reflective of the everyday South African woman. This is a small sample, obviously it gives new insights, but it is not necessarily that this speaks to the experiences of every single nurse and midwife within the South African context. And I think in terms of my positionality as well, was also that I wasn't a healthcare provider, right? Whilst obviously this meant that it was a useful space for me to bring fresh perspective, but it was also that I wasn't, like, I am not a nurse, right? So even though, the stories that I was told, the data that I collected was useful in relation to being able to articulate that, but it also meant that I do not have the lived experiences of these nurses. And so I think the takeaway is that as much as possible, I have tried to address my own biases and limitations as it relates to the research, but at the end of the day as well, the data that I present is also from my own perspective. So just acknowledging that and ensuring that, when people read as well, they do. So, I mean, it was an exciting process.